Welcome to On the Mark. I'm your host, Howard Mark Rubin. I am so excited to present this podcast series addressing our rapidly changing world and how it is affecting industries and people in unique and interesting ways. As John F. Kennedy once said, change is the law of life, and those who look only to the past or present are certain to miss the future. The business leaders and personalities who I will be interviewing in these podcasts certainly look to the future. And I hope you come away with information and inspiration that helps you adapt in both your business and personal lives. You can find these podcasts on all major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, GoetzPlatzer.com. Welcome. And I have a very exciting guest for you tonight and a very exciting topic. The guest's name is Arsenio Rodriguez. He's of counsel to my law firm, Goetz Platzer, and he's in charge of employment relations, employment harassment cases, labor cases, construction cases dealing in these areas. And we're going to discuss this area. This area happens to be a pet peeve of mine because, as you know, I'm not the most woke person in the world. When I started practicing law many years ago, there were certain protected classes: your color, your gender, your religion. Now it seems like anything's a protected class, and employers have a landmine to have to deal with, and it seems to be getting worse and worse and worse. So first, Arsenio, welcome to the show, and tell us a little about your background.
Absolutely. So first of all, thank you for having me. I've been an attorney for 15 years, of which about 10 of that has been doing labor and employment cases. I initially started as a DA in Queens. So that's how I started my legal career. And then since then, I moved over into the labor and employment field. Currently, I do labor and employment matters here at Goetz Platzer. I work on construction litigation cases, of course. And I also have been kind of handling the middle range where you're dealing with prevailing wage cases. You can still get discrimination cases in union environments and things like that. So I am really in this weird little middle ground where we're balancing both. But my specialty, my bread and butter is labor and employment.
Okay, now I mentioned protected classes.
Yes, you do.
And I mentioned when I started practicing law, longer probably, well, not really, maybe you were alive, but you were a baby, that there were very few. Yeah. And it seems to me every time you turn around,
yes,
there's another protected class. In fact, I don't know that at-will employment actually exists anymore. You can't just fire someone because you want to fire them. If I have an employee who I don't think is doing a good job, I can't fire them anymore without going through a whole checklist of items because they'll find some category somewhere that they're being discriminated against. Give me your reaction to that and how you feel about that.
So what I would say to you in that aspect is, New York is a very liberal state. So we happen to do business in New York. So we do have a greater number of protected classes in comparison to other states. But even on the federal level, protected classes have been increasing. What I always tell my clients, and I think the number one violation that we make as employers or my clients do as employers, is you don't document enough. You can still do at will. Absolutely. And listen, you can't stop anybody from suing whoever they want. But if you have the documentation to show, hey, so-and-so is a bad employee, then you shouldn't worry so much about what the repercussions are if they were to take legal action. Unfortunately, a lot of employers don't do that. And then when they raise that they were discriminated against, a judge looks at the employer and says, well, you said it was for cause. Show me what the reasons were. And oftentimes the employers don't have that background.
Does the employer also have protection? In other words, if an employee said to me, you know, you're a goddamn dirty Jew.
Yes.
So can I fire him for saying that?
Absolutely.
But then wouldn't he say that it's freedom of speech or he would have some rights? Do I have to document that? If he says it to me once, do I have a right to say that?
Well, hate speech isn't protected. That's been settled. But what I would say to you,
what if he sexually harasses me? What if he or she puts their hand on my arm, not something blatant, but puts their hands on their arm and makes me feel uncomfortable?
Well, did you tell them that it makes you feel uncomfortable?
Well, how many times do you have to tell them before I can let them go?
Well, what I would say to you
is how blatant is it have to be?
Well,
I don't want to get graphic, but how blatant is it?
I mean, there's a sliding scale. There's a spectrum, clearly. But I would think in a situation, for instance, when he insulted you and he called you a dirty Jew, if you fired him on the spot for that, you would be fine. But document that, of course, right? If it's a question of the employee is touching you in a way that makes you uncomfortable, document that, let the individual know. And if it happens again, I would say you're in your right. But I don't like this idea that employers have less rights than employees. The only thing employers have is a greater responsibility to document. And so that's what I would say is the most important aspect of it. But if you have God forbid, a hateful employee, you have every right to let that person go. You just have to document it. That's the only requirement.
And what happens if it's not to me, it's between two employees of the company, and one employee says something derogatory about the person's weight or the person's looks, or they're stupid or something like that, and you're the employer. Now, as the employer, you don't want to be involved if you don't have to be involved, but you're required to be involved in
Absolutely.
Right? What's your requirement when you have two employees who are fighting?
So if you are a supervisor, or you are, for instance, a small company, the actual employer, it's just your business, you have a duty to deal with that situation. So as much as you don't want to, I mean, the situations that I think are the most complicated, right, is, let's say you have a really strong employee. Let's think about sales, makes a ton of money. And then you have another employee who's not. But the employee who's making the violations is the more productive employee, the more successful employee. The responsibility is on you. Let's say you don't want to do anything. Let's say you transfer the other employee. Let's say you fire the other employee. That employee 100% has a legal recourse against you for doing that. So in those situations, you have to get involved and you have to make the tough decisions. And that's where I think sometimes people go wrong.
And how about romantic relationships in the office? Two people who it becomes clear in the office are in a romantic relationship. How does an employer deal with that situation?
So it happens more often than you think, right? You spend.
I think it happens often.
Right.
I think it happens.
So then maybe it happens often as you think.
Yeah, right.
But because you spend so much time together, right. I think. Again, I hate falling back on it, but for the next however many minutes, you're going to hear me say it a lot. You got to document it. I recommend to all my clients, even to ourselves, looking at our handbook, that we have a policy on romantic relationships. In general, you can forbid it, but it's incredibly difficult to enforce.
You can't forbid it. You have the right.
You have the right to forbid it,
oh.
But the problem is, good luck enforcing it, right? Because if you forbid it, then that's a violation of the policy. Are you going to terminate both employees, one employee or the other? And if you do that, or if you don't do that, excuse me, then it looks like the policy isn't universal. I don't recommend saying that you forbid it. What I would recommend, and similar to our policy, I don't want to, just say that we're doing it right, but we have a strong, we politely ask strongly that it not be between people of different ranks. That's where you get into trouble. If you have a relationship between a supervisor and an employee who either directly or indirectly reports to that supervisor, you run a really big risk, especially if the relationship doesn't end well. It's less dangerous if the two employees are of the same level, or they just happen to be in the same company but in different departments. But I would also say to any company, keep an eye on that, because if one of them gets promoted and you get that supervisor-employee relationship, you need to be aware of it. And I'm going to say this before we jump out of it. If you have a supervisor-employee relationship and that relationship ends, even if everything that happened before then was consensual, you could have an issue with sexual harassment in the future. So you have to be aware of that, because if the employee says, so-and-so sexually harassed me, you can't say, well, you guys were intimate in the past. That's not an excuse anymore, especially if the relationship's ended.
But you don't think that employers should try to prohibit those relationships?
I think it's just,
from an employer stand of view, what do I don't want to be involved. I would rather just prohibit it, but that's just not reasonable, or that.
I think that's where it comes. I think practically speaking, it's not reasonable. You're, on average, minimum 40 hours, but in a lot of firms, whether it's especially professional, legal environment, accounting,
right,
you're spending 50, 60 hours a week in one place. You're hiring somebody, they're in their 24, 25, they're of that dating range, or even somebody who's older, and they happen to, get into a relationship with someone they see as often as they do. I think it's incredibly difficult to say you can't do that. I think the one thing you can require is that they tell you. And I think that's the most important part, because if they tell you, then you can watch it and you can monitor it and you can be aware of it. Because when it ends, if it ends, that's when you have to have, as an employer, a heightened sense of what is going on between those two individuals.
Okay, so you used the term a couple of times, I think, documented.
Document.
How does that actually work? Is there has to be a person who thinks that whose responsibility is to record things, that things have to be reported? How should companies handle this documentation concept?
Sure. I think it depends on size. I think the bigger the company are, the more likely you have an independent HR department, which is where those complaints, I should say, should go. If you're a smaller company, I think you need to have designated supervisors. If you're an employee, like a firm that's got 10 people, 5 people, it's got to be the person who's owning the company or the president of the company. But you do need to have a set structure communicated to your employees. If you have a concern, if you've been discriminated against, if you've been harassed, this is who you speak to. In addition, if you use payroll companies such as ADP or Paycom, many of them actually offer anonymous tips or anonymous complaint systems or procedures where an employee can say that, and then that information would get to you as the employer. I think if you lay it out, how to complain, that's number one. The second part, which is where people usually mess up, is how did they investigate and what was the structure of that investigation?
And how should they investigate?
At the very least, you have to make sure that if somebody does complain, that they're not liable for retaliation because of the complaint. So they have to feel safe to complain. And then after that, let's say in a situation of sexual harassment, you should speak with the alleged victim. You got to speak with the alleged harasser. You need to find out if there was any other witnesses. Lots of times in some of these environments, there are cameras. Check your camera system. And then you need to make a determination and follow up on it. So if you find out that someone was in fact sexually harassed, you have to take disciplinary action. Because if you don't, it looks like you preferred the harasser over the victim. And now the victim's work environment has completely changed. Now they're working in a place where they feel like they're being harassed. They feel like they can be harassed. And now the employer is opening himself up to a hostile work environment, a lawsuit, possible discrimination on behalf of gender. So there's all these things that you have to be worried about. So you have to investigate. You have to check all the resources. You have to make a decision. And then you have to act on that.
And let me ask you something that's not as blatant. I call it the perfume wars.
Yes.
Where you have in an office, maybe someone has body odor.
Correct.
Maybe they're wearing some perfume that someone finds offensive, maybe some hair care product that they find offensive. And the person who's wearing it thinks it's their right.
Sure.
And the person who's offended by it says, well, it's hurting me. It's having some effect on me. And other than trying to move them away, which both of them, I've had this situation, both of them have said, I didn't do anything wrong. I don't want to move. Let the other person move.
Sure.
Okay. How do you handle a situation like that?
So I'm going to hit you with that word again, document. First thing I would say is in your handbook, you should have a personal hygiene and a scent policy. Okay.
A scent policy?
Yes. So you run into two issues. The idea of there being an odor in and of itself is not the problem. The problem is this. What if the person who has the odor has a disability? Now you're opening yourself up to disability discrimination. So you need to be aware of that. If the person has a disability, you got to start going through the ADA path, American with Disabilities Act path. Is there an accommodation? What it is? Do we have medical records? That's on one side. On the other side, if the person who's receiving that smell, let's say it's a perfume situation, and that reactivates their allergies. Now you've got an employee who's going through a medical situation because of a smell. You have to worry about, again, ADA. So what I like to say is in our policies or in the employer's policies, make it clear. We do have personal hygiene. We do have a request that you maintain a certain level of hygiene and so that you're not filling the office with a body odor, and that you have a policy against smells that could be found offensive by other people. If you have it in the policy and you put it in there that there could be decisions made off of that, then you're in good shape to do whatever you need to do. The other thing too is always put in those policies. If there's a medical condition though, please let us know and we will work with you when it comes to that. But you are perfectly within your right as an employer to say that smell is too strong. It is in violation of our policy. Can you please pick a different perfume or a different scent? But yes, like in your situation you're talking about, if you can move the employees, that's great. If they don't want to move, then you got to go through other
Right.
means.
Then let me ask you something in a post-COVID world. During COVID and shortly thereafter, many offices were only requiring people to come in 3 days a week.
Yes.
And that became somewhat of a norm.
Correct.
And that's, in my world at least, or my clients' worlds, that's kind of becoming extended. People want people to come in more. Employers want people to come in
Back to work,
more.
yeah.
So if you take someone who you hired and only was required to come in 3 days a week, and now you want them to come in 4 days a week or 5 days a week, and they respond, well, I have childcare issues, or I can't sit in a train for 5 straight days in a week to try to make it into an ADA claim. Is that something the employer has to be worried about, or can the employer say, no, from now on you have to come in X amount of days a week, 4 or 5 days a week?
Sure. So the first thing on that is the COVID paid sick leave law that was passed in New York City. That's expiring in July. So we don't have to worry so much about leave. Now, as a result of that saying, we're going to come, you have to come in, a business can't do that. I think it was last week, JP Morgan Chase made that change. All employees have to report back to the office. If you're going to do that, the best way to do that is to make it universal, okay? Because that prevents you from getting that discrimination issue. If you're telling everybody has to come back, then everybody has to come back. If you're picking on 1 or 2 select individuals, then they can allege caregiver. I'm a caregiver. You're discriminating against me because I told you I can't, and you are just asking me. The second thing is there an employee agreement? If you have an agreement and it's in a contract, you get to work 3 days a week in the office, 2 from home. There's nothing you can do.
Well, that's contractual.
100%.
That's a different thing. I'm not
right.
worried about that.
But if you're also, when it comes for everything else, I think the one thing the employer has to understand, and it gets lost, is if you tell everybody they got to come back, the employee can just say no and quit. And you can't be mad, right? Because in the end, there are still going to be jobs, from what I can tell, that are going to allow work from home in some capacity. So remember, if it's at will, it's both ways. And what I've seen is some employers call me like, I told them they have to come back to work and they're going to quit.
Arsenio, it's not both ways. An employee can always quit.
Yes.
For whatever reason.
Yes.
They don't have to worry about this checklist of all these items. They can just quit because I don't want to work here anymore. The at will on the employer side, that's where it's changed.
I just want you to ignore the little asterisk next to at will. Okay. That's
okay. Right. So let's talk about a situation in an office that there is some I'll call it a differentiation. I won't call it a discrimination. Like, for instance, in most law firms, they require the assistants, the people who work for the attorneys or work for the accountants, they have to come in 5 days a week because the attorneys need them there. Now, the attorneys, because they can more often work at home and do their billing at home and do their work at home, they may be able to work 3-4 days a week and not be required to come in 5 days a week. Can you differentiate between classes of employees or job duties?
Yes.
To have someone come in and others don't have to come in?
Absolutely.
Because you said before that you have to be careful in making it a uniform situation.
But a uniform against that whole level.
Of
right. So like if you've got staff members and you're saying all staff have to be in 5 days a week, you're fine. If the attorneys or the accountants or the architects, they can have a different schedule, that's okay. The issue that you don't want to get into is that within people who are similarly situated, you are starting to say you're different than you, than you, than you. That's where you run into a problem. I've worked in many firms where the staff have to be in 5 days and the attorneys do not. And that's fine. It's when you start saying, no, you particular staff member have to be in 5 days. All you other ones can work 2 days from home.
Well, what if this isn't the situation. I'm giving you a hypothetical using myself. What if I want my assistant to be in 5 days a week, but you, as another attorney, have a different assistant, and you say, you know what, you can come in 3 or 4 days a week. Can we do that?
So technically, yes. However, if I was counsel for that firm, I would say you probably might want to figure something out here. Because again, anytime there's differences, whether it's actually the truth, Howard, or not, if I feel like I'm being discriminated against and I can figure out one of those classes where that could fit in, you're open to liability. You might win, but you got to pay for legal fees. You got to pay for court fees. You've got to deal with that issue. So in my mind, if you're going to do that, if I'm the employer, I bring in my attorneys and I'm like, we've got to figure this out. Because if we're going to do this across the board, we're going to be okay. If we're going to start picking different scenarios, we're going to run into trouble. Now, listen, it'd be hard not to ignore. There are some lawyers or salespeople that just produce more, make more. If they want to have their own little private rule on how they handle their own team, as long as the company documents it, formats it, I think you can get away with it. But just understand, no matter what, you will be open to some kind of liability. Anytime there's change, anything is possible.
So let me ask you about using incentives to get people to come in. Can I say that if you come in 5 days a week, I'm going to pay for your transportation costs, whether it's your train ticket, your subway, your car, whatever it is. But if you don't come in 5 days a week, you don't get your transportation at all paid for at all.
You can do that. You can do that. I mean, I've heard stories of companies that are paying for meals. They're providing meals if you come in on the more common days that people take remotely are like Fridays, Mondays. But they're saying if you come in, we'll pay for meals. We'll provide this. You can make it so if you do X, I'll give you Y. Do not discriminate against the person, though, if they decide that they don't want your incentive. It's nice that you're paying for my transportation. It's nice that you're giving me meals. But I don't want to take it, and I want to still continue to work from home. Okay. If you make that the rule, then you can't get them in trouble if they want to abide by it.
Now, how about end of the year bonuses? When I decide, at the end of the year, our firm and almost every company gives some type of bonus to employees.
Mm-hmm.
Can I take into account how many days a week someone's come into the office and determining bonuses? Can I say, I'm giving you 50% more than this other person because you showed me that you're a team player, you've come in 5 days a week, and the other person only came in 3 days a week. So I'm going to give you a much bigger bonus.
So if it was strictly on that, I can say it could be a factor you can consider, but it can't be the deciding factor. And the other thing I would say to you, Howard, though, is
what does that mean? It could be a factor, not the deciding
factor.
It
can't be the number one reason why you decide to give somebody 50% more. And the other thing I will tell you is, again, you're opening yourself up to liability. Let's say this other person who's in 5 days doesn't have kids. I do, and I've got to pick them up. So now you're discriminating against me because of my caregiver status. So if everybody who has no kids is making 50% more bonuses than everybody who has kids, and let's say the work product is pretty close to each other, you've got a problem.
But isn't it very subjective when you're talking about bonuses? And if you're not using a like an hour kind of quantum kind of thing, but it's the quality of the work.
Yeah.
And does that allow you then or give you more flexibility to I don't use the word discrimination, I use the word differentiate.
Sure.
To differentiate of who's getting what bonus.
Okay, so then we're going to go back to my document. Did you document? Did you speak to the individual who's working from home and saying, hey, we've noticed that your work product isn't as good as we would like it to be? Because if you're just going to say at the end, first of all, before we move on, make sure you say all bonuses are discretionary. That's number one. And whatever policy you have and whatever contract you have, that's number one. Number two then is, if we get to the end of the year and you're like, you get 20 grand and you get 10. And then it's like, why? Our work product's the same. No, it isn't. Your work product is worse. You never told me. You never explained to me. You never said anything to me. So now again, it looks like people are being treated differently and you don't have the background to support why. And it is the employer's burden to show why we're treating employees differently. If you fail that burden, you're liable.
Was this 10 years ago? You were practicing 15 years. 10 years ago, was it just like this? Or is this something that's evolved to become, because it seems to me to be an awful big burden on the employer to do all of this. Was it always like this?
Yes. In my opinion, in my practice time, yes. So for instance, when I first started, I did a lot of wage and hour stuff, a ton of wage and hour stuff. Worked a lot with restaurants, retail businesses, you're supposed to pay this person X number of dollars and then overtime at X number of dollars. Lots of times, especially with smaller businesses, they don't have timesheets. They don't have any recordings, nothing like that. Or sometimes places would just pay $500 in cash for all your hours worked. When a lawsuit would happen, the court immediately shifts when they make their allegations and says, you say you paid them correctly. Yes, Your Honor. Prove it to me. So now the burden is on the employer to show their time records, their wage records, that they did proper taxes and withholding. They don't have that. There is a presumption that the plaintiff is correct. So what I would say in that situation is, yeah, even with sexual harassment, did you document sexual harassment? Did you follow through with an investigation? Did you get a complaint form? Do you have a complaint form? So I think in my years of practice, the burden has always been on the employer. I just think what you're seeing is judgments being issued, especially in the wage and hour context. And you're seeing millions of dollars in judgments. And now employers are starting to go, wait a minute, what do I have to do? And I think that's where we jump in. A firm like ours, Howard, we jump in there and we go, let's look at your records. I've done this before. I've gone to employer sites and said, you need this document, you got to change this, you got to fix this, and you got to do this. And then if something goes wrong, you call me and I'll jump in. And I think that's one of the big things that people need to understand is it is not difficult to comply, to be in compliance, but it does take an initial investment, but you're going to reap benefits of it down the line.
And let me give you another situation that happened. Some of our lawyers, I think I'm one of the ones who's guilty of this, sometimes use what I call salty language. Would use the F word or some words like that. Sure. Nothing horrendous, but using curse words. And if I'm talking to somebody who I know is not going to be offended by it, say so I don't think you would be offended by that if I use that kind of language. And in our conversation, I'm using that language, but somebody overhears it. Who I'm not talking to, I may not even be aware that they're there overhearing it, but they overhear our conversation, what I've said. Mm-hmm. Do they have a claim against the company for that?
So I would say salty language, of course not. In my opinion, I wouldn't say of course not. I would say no. I mean, if you get a complaint from an employee that it's creating for them a hostile work environment, you may be in trouble there. But I also believe if you go past the salty language, if you go into anything that'd be considered a stereotype, a discriminatory comment, a slang phrase that maybe is offensive to a certain group, a racial slur, God forbid, or something along those lines. It is important now in today's modern world to understand that your voice carries. And if you're going to speak in a public area and you're going to say things, you're kind of like a radar on a submarine. You're like that middle dot, and then it pings out. And whoever that hits, that could be a possible plaintiff in the future. So I think if you're going to have conversations like that, I recommend having it behind closed doors. And like you said, I recommend making sure the person you're talking to is totally cool with what you're saying.
Right. I mean, there are times that I'll tell a joke that may be a little off color, as you know. And
at times.
Rarely, but occasionally it happens. And they're always funny, right?
It's hysterical.
All right. So, but someone who I'm not talking to, because I know I would not say that kind of joke to that person, overhears that joke.
You're in trouble.
Right. And I guess they write it down. So they would then go to the designated person we have for HR.
Correct.
And they would complain about the joke.
Correct.
Right.
Yes.
Now, what if they don't complain about the joke, but they're fired a year later? And now they're saying, you know what? A year ago, he told this joke.
Sure.
I never told anyone there, but I was really offended by that. Yeah. That's one of my courses of action.
Yeah.
Is there like a statute of limitations that they have to report it?
No.
It could be any time.
Internally, there's no statute of limitations. Of course, externally, they have a certain amount of time to report it. It's generally in New York, 3 years. But what I would tell you is, remember, we cannot stop. And I think this is something our clients sometimes struggle with. You can't stop anybody from suing anybody for anything.
Right.
So if they make that claim along with other claims, when I read that letter or that complaint, I say, we're going to be okay on that one. If they have other ones that are stronger, those would be my concerns. If they're just going on a whole bunch of complaints that were undocumented, unreported, there is a defense to say, how could we have stopped Howard from saying that joke in the future if we didn't know? Now, what I will tell, and I will caution people is, if somebody who has a duty to report hears it, as well, that employer becomes liable.
Well, that's my next question. Say that I tell you a joke.
Yeah.
And somebody else who's also not offended by the joke,
Sure.
but is maybe another partner in the firm.
Sure.
Now my partner in the firm is supposed to report to HR that I told you, who was not offended by it, a dirty joke.
So you got to be careful here. Like if they can be considered a supervisor or a manager.
Well, we have a law firm has equity partners.
Fair enough.
I'm an equity partner.
Sure.
There's another equity partner who
Correct.
overhears it
Correct.
who wouldn't be offended by it. I'm just asking theoretically. I don't think it would happen in practice, but does that person have an obligation to tell HR or to tell me that was inappropriate to say to you?
The answer is yes. And I would like to believe, if you have that relationship, that the equity partner would come to you and say, Howard, like, you can't, you really shouldn't. Technically, that equity partner should also go to HR and say, Howard said this, I heard it. And then there has to be, listen, the penalty for you could be as little as a write-up, just a quick writing in your file and you put it in. But not doing anything can be way more dangerous. Because let's say you make a second joke. Now that's my line. Now I'm offended. Now I go to HR and I'm like, he said this on this day and this on that day. He's a racist or discriminatory or whatever. You got a problem. So it's better if you're there, you've got to make sure that you nip it in the bud, so to speak. And I'm going to say this to you, and you've never heard me say it, but it's something I say. Unfortunately, we live in a world where every employee is a prospective plaintiff. And if things end badly, it has been my experience that when that person gets home and they're done being mad, or even while they're mad, one of the first things they do is they look up if they have a claim, because they're being vindictive and they're being mad and they're upset. They feel poorly treated. So in order to prevent that, document, treat your employees well. And if you have any hesitancy on what you're saying or where you are, don't say it.
Now, is there a different level of, I don't know what you call it, inappropriateness to use something like the N-word, as opposed to, no, I'm saying,
okay,
as opposed to using the F word to someone? Is it a different standard that one is worse than the other, or is any word that the hearer hears that's offended by it, is it basically the same? Or are there certain words that have a greater, you understand what I'm saying?
I understand exactly what you're saying.
Greater impact, or
yes,
they're worse to say.
That's exactly right. There is, what I would tell you is and I would counsel our clients, again, you're better off not doing it, period.
Well, of course.
Right.
I'm just trying to get, is there
Sure.
a graduation?
So now what I'm going to tell you right now is, if we go to court, let's say,
right,
there are certain words that a judge or a jury will look at, and that is immediate impact, where you are running uphill, where I would advise my client, we have to really think about resolving this before we get in front of a judge or a jury, because of the level of the weight that word carries. And there are certain words that have that. A lot of racial slurs absolutely carry that weight. So I would caution people to say, technically they're the same, but in reality, they're not.
Now, there are different places a claim could be made. I just want you to briefly.
Sure.
I know there's city agencies you can make a claim without even a lawyer.
Yes.
And you can get a lawyer, and the lawyer has a choice of bringing it to federal court or bringing it to state court. Could you explain what the differences are?
Sure.
As to where we bring a case?
So as an employee in the city of New York, you can go to the New York City Human Rights Agency. You can go to the New York State Division of Human Rights. You can go to the EEOC, which is federal, or you can get your own attorney. Okay. And they can file claims depending on what violations they're alleging, either in federal court or state court. The interesting thing about the state and the city is, if you make a complaint on your own, they can decide to take the claim on for you. And so they will be representing you in the situation. What I have seen most of the time is that these individuals hire employees. Hire attorneys to take on their cases. The timing of each one differs. So I believe in the EOC, it's like 300 or 330 days you have until you make your complaint. In New York, like I said, the statute of limitations now is 3 years to make those complaints for discrimination and harassment. And then wage cases are different, So in the end, while you do have different places, you can go to the DOL for wage cases, right? New York State Division, Department of Labor, if you want to. You can go to for certain public works jobs. You can go to the comptroller's office for New York City. My experience has been most people hire an attorney, they figure it out. Most plaintiffs' attorneys work on contingency. So if they feel like the case has got some weight, you don't have to pay anything up front, which for many employees is a bonus because they don't have the money to pay for attorneys on an hourly rate. So I think, there are different vehicles. What I would counsel all of our clients and anybody who would want a prospective client is if you get anything, even a demand letter, take it seriously because you don't know whether that case is a $10 case or I just saw a verdict handed out, I think it was in 2023 for discrimination for $11 million. You don't know. So take it seriously.
And you should contact your attorney, right? An employment attorney who knows what he's doing at the earliest stage possible so you can strategize and decide how to deal with it.
Maybe an attorney who's on a podcast with a guy named Howard,
right?
Who could possibly be of service.
He'd be a great
so I absolutely believe that.
Let's talk about handbooks for a minute.
Absolutely.
I know that you feel strongly, and I certainly agree with it, that companies should have employee handbooks.
Yes.
Can you explain why it's important for a company to have employee handbooks and what should be contained in the handbook?
Yeah. So I think handbooks are really important because it is a one-stop shop for your employee. It's the beginning of your meeting your burden of documentation, Howard. So if you're putting everything in your handbook, you are now telling your employees, we have policies against this. We care about sexual harassment. We care about discrimination. We care that you're taken care of. And if an employee ever has a question in your handbook, you're going to have who they can talk to, who they can complain to, what the investigation process will look like. All of that is one resource that you can provide them. And it's the beginning, like I said, of meeting your burden. You can go to court and say, look, they knew what they had to do. They didn't do it. Or this doesn't rise to this level. So I think documenting that, having it there is extremely, extremely important. And it allows you to send a message to your employees. We care and we will not stand for this kind of conduct.
I also, I represent a lot of people in the commercial real estate brokerage industry. And it's important to have in those handbooks is what the broker gets upon termination. In other words, compensation issues, absolutely. Not just employment claims, but compensation issues. When someone leaves and there's a case that he might have gotten a commission on, he may not get a commission when he's terminated, or he gets a certain lesser amount because the deal's in progress or what he gets. And if all that's spelled out in a handbook, it makes it easier, particularly in situations where someone doesn't have an employment agreement. If someone has an employment agreement, that supersedes what's ever in the handbook, correct?
That's correct.
So for people that don't have an employment agreement, and you can have an employment agreement with someone that's even an at-will employment agreement.
Correct.
It could be terminated at convenience.
For cause or without cause.
Without cause, right. Well, but it's always interesting that it's not really enforceable against the employee, because if the employee leaves, even if you have a 3-year contract with the employee, and the employee decides after a year, you know what, I don't want to work here. Good luck for the employer enforcing that contract.
I mean, people have done it, but yes, it's an uphill climb. I agree.
That's maybe in Major League Baseball you can do that, but I'm not even sure there.
I'm not sure you did either.
I don't think Juan Soto is going to try to get out of his
contract.
Not with
that money. Are you kidding?
Well, when he gets, maybe he'll take an option if the prices go up. But other than that, I think you have a situation that employee handbook is important, not just for the HR issues, but also for the compensation issues and a lot of other issues. And I know that you do a lot of employee handbooks. We recommend to the clients, and they should also update their handbooks, because things change as the world is changing, as situations change. Those handbooks should be reviewed by an attorney.
Absolutely.
And updated. Absolutely.
And I'll give you an example. So this year alone, there's been new policies with respect to prenatal leave. So if you're pregnant and you need to go to certain doctor's visits, you now have an extra 20 hours of guaranteed sick leave under the city of New York. You have other issues with now what's a new protected class. So it's important to look at. There's a new an act called the Clean Slate Act in New York, where if you do background checks, right? Let's say you're a firm that has to deal with a lot of sensitive information, people that do bankruptcies, things like that. You have access, they do a background check. If you find, as part of your background check, you get a criminal history report, you have to give that criminal history report now to that employee, even if you don't take any adverse action. In the past, if you made a decision based off on it, and it was adverse, then you had to give it to them. Now, doesn't matter if it's adverse. You got a criminal history report, they got to get a copy of it, and that's new.
There's one other, we're running short of time, but there's one other issue that I wanted to cover with you that I didn't, and that's in interviewing and hiring people.
Yes.
What can you ask a prospective employee, and what can't you ask? Or what can't you ask a prospective employee?
Well, I don't know if we have enough time to go through all that.
We only have a couple of minutes.
Right. But what I would say is, if it's a protected class, you can't ask about it. You can't ask about prior salary. You can't ask about caregiver status if they intend to be have families, reproductive health situations. You can't ask for a photo. You can't. I'm just trying to think real quickly through it. You have to be very careful about. For instance, you can ask if they voluntarily want to give information about a disability, but you can't ask, are you disabled? Are you going to require an accommodation? So it's important that you understand that there are questions that are no longer allowed to be asked, period. And there are questions that you can figure out different ways to ask where you're still legal about it. But in the end, again, the burden falls on the interviewer. So if there's clients out there that have any questions, any doubt, want to revisit their interviewing process, right, I recommend contacting counsel, contacting someone like us, so that we can go there, we can work the process through.
I could go for another hour. We can go for another hour on this. There's just so much, and this has been so informative, I think, to a lot of our clients. And for those out there, if you're looking for an attorney who knows this area of the law, you couldn't do better than Arsenio. He's terrific in this. He gives you straight answers. He doesn't give you a lot of lawyer gobbledygook. He'll give you a straight answer. And other than being a Yankee fan, he's a great guy. But
someone consider that a bonus.
Well, not me. It's a Met fan. But I want to thank you all for joining. I hope you enjoyed this podcast today, and I hope you learned a lot. And I hope to see you at our next podcast, which is I do one a week, and we'll be doing it again. And thank you for your time. And have a great day and a great weekend. Take care. Bye-bye.
Bye.
I hope you enjoyed this episode of On the Mark. I started this podcast by quoting John F. Kennedy and would like to end it with quoting one of my favorite baseball players, Nolan Ryan. Enjoying success requires the ability to adapt. Only by being open to change will you have a true opportunity to get the most from your talent. I wish you success in staying ahead of the curve instead of behind the 8 ball. Thank you for tuning in.